Good afternoon, Your Honors. Nick Spangler for the state of Tennessee. If I could, please, I'd like to reserve 5 minutes of rebuttal time.
All right, Jim Spangler.
Thank you. Your Honors, this is a 40-year-old capital case that has withstood many collateral attacks. It's 30 minutes per side, right? That's correct.
So I say,
I'm sorry.
You say it out loud. I'm sorry.
I'm sorry.
All right. So it's 30 minutes, correct?
That's correct, Your
Okay.
Honor. I believe 30 minutes for our side, 20 minutes for Mr. McKay, and then 10 minutes for DA Mulroy.
All right, correct.
I'll start again. Your Honors, this is...
Sorry for interrupting.
Sure, no worries.
I had it right.
This is a 40-year-old capital case, and it's withstood many collateral attacks over the decades. And for this latest attack, which comes in the form of a time-barred error quorum nobis petition, the General Assembly saw fit to assign the Attorney General the responsibility of defending these 40-year-old judgments in the trial court. And McKay argues here, and the trial court found that this reassignment of statutory authority violates Article 6, Section 5 of our Tennessee Constitution. And instead of simply supporting the AG and defending these final judgments from collateral attack, the DA actually sides with McKay and argues that our General Assembly violated the Tennessee Constitution by infringing his discretion to, as he says, concede or contest the applicability of the death penalty and the merits of McKay's quorum nobis claims. Your Honors, there is no textual, precedential, or historical basis to overcome the strong and mandatory presumption in this case that our General Assembly acted within constitutional bounds in making this reassignment of statutory collateral defense authority. So, Your Honors, the trial court here erred in striking down the act, erred in disqualifying the Attorney General, and we respectfully ask you to reverse that decision. So I'll start here with the plain text of Article 6, Section 5, which is where I think we have to start. And that text simply does not say that the DA is the only attorney who can represent the state in the trial courts of a given district. The relevant sentence says, and this is the sentence that establishes the constitutional office of district attorney, and it's the sentence that McKay and DA Mulroy rely on most heavily. It says, an attorney for the state, for any circuit or district, for which a judge having criminal jurisdiction shall be provided by law, shall be elected. So there's a lot of fors and commas there. It's a little bit to unpack, but it's not an overly complicated sentence. And the first thing I think to note is that it affirmatively uses non-exclusive language. It says an attorney for the state. It doesn't say the attorney for the state. And our Supreme Court has expressly interpreted that use of the indefinite article "an" as a signal of non-exclusivity. But then beyond that, and I think more to McKay's and D.A. Mulroy's argument here, is we have this clause that says, for which a judge having criminal jurisdiction shall be provided by law. And McKay argues that that clause exclusively tethers the DA to trial judges having criminal jurisdiction in a given district. But that is not how that clause operates. That clause clearly modifies circuit or district to mean that the judge having criminal jurisdiction is provided for the circuit or district. That clause does not modify attorney for the state to mean that a judge having criminal jurisdiction is provided for the attorney for the state. Obviously, judges are not provided for the attorneys for any party. They are provided for the circuit or district in which they serve. So we submit that a plain read of this constitutional text lends no support to McKay's position that the DA is the only attorney who can represent the state in the trial courts of a given district. And then moving on to the precedent, the Tennessee Supreme Court precedent and all the precedent in Tennessee interpreting Article 6, Section 5 provides no basis to overcome the strong presumption here that this act is constitutional. The Supreme Court has only twice found violations of Article 6, Section 5, and both of those cases involved laws that interfered with the DA's authority to either initiate criminal charges or oversee and prosecute pending criminal charges. No Tennessee court has ever hinted that the Tennessee Constitution gives DAs any authority to defend final judgments from collateral attack. That authority has always come exclusively from statute. What our Supreme Court recognized in 1897, Your Honors, in the Spurgeon decision is that the primary purpose of Article 6, Section 5 was not to constitutionalize or list or detail any particular duties of either the DA or the AG. Rather, the purpose was to merely specify how those two constitutional officers attain their office. Obviously, the DA is locally elected and the AG is appointed by the Supreme Court, but the purpose is not to list out or detail any specific duties. And then finally, Your Honors, we look to the history, and there's no historical support for the idea that the DA is the only attorney who can represent the state in the trial courts of a given district. And here, the primary example that we cite is habeas corpus, right? Like the Tennessee AG represents the state in habeas corpus matters filed not just in trial courts, but in trial courts that have and exercise criminal jurisdiction, including in trial courts that exclusively have criminal jurisdiction. And that would be criminal courts. So we're talking about circuit courts that exercise criminal jurisdiction and criminal courts that exclusively have criminal jurisdiction. And our Supreme Court has recognized that habeas corpus, like quorum nobis here, like post-conviction, like all the other means of collateral review in dispute here under the statute, is definitely a means of collaterally attacking a final criminal judgment. But then the other example we cite is the fact that the AG represents the state in all civil cases where the state is a party before trial courts that have both civil and criminal jurisdiction. And here again, we're talking about circuit courts that are clothed with both the authority to hear civil and criminal cases. And this directly undercuts McKay's position and his reliance, again, on that one clause from Article 6, Section 5 that says the DA is exclusively tethered to trial judges having criminal jurisdiction. Your Honors, the framers of the 1870 Constitution could not have possibly intended that Article 6, Section 5 would give DAs any authority to represent the state in the collateral review proceedings disputed here. And the reason for that is all the statutes creating those collateral review procedures postdate the Constitution's adoption by almost a century. So it's just logically impossible that the framers contemplated either having those procedures or giving the DA any constitutional authority under those procedures. Your Honors, unless the court has any specific questions about the policy arguments raised by Mr. McKay and DA Mulroy, I'm not going to touch on those other than to say it's well established by binding Supreme Court precedent that policy considerations have no place in a judicial consideration of a statute's constitutionality. And the reason for that is the act here, the statute declares the policy for the entire state for all Tennesseans, including those in Shelby County.
Let me ask you a question about this non-exclusivity argument that you made.
Sure.
And from Article 6, Section 5. And so you're saying the Article "and" somehow means that it's not exclusively the Attorney General appointed by the Supreme Court or not the district attorney elected by the people.
That's correct, Your Honor. I mean, it's two things, really. It's the fact that it says an attorney, not the only attorney that can represent the state in the trial courts, and also the fact that there's no tethering language. There's nothing that says that a judge having criminal jurisdiction is exclusively tethered to the DA. There's no language that says that in Article 6, Section 5.
Well, both of those sentences uses the singular his in the old style, but certainly the singular his office in reference to an attorney general or an attorney.
I think it's singular in the sense that there is only one district attorney in a given district. The point is that's not the exclusive attorney that can represent the state in a given district, is I think our point. Just as it says an attorney general, but the attorney general is not the state for all matters in state courts. The district attorney obviously sort of has concurrent authority in the districts in which they serve.
Well, doesn't Article 6, Section 5 provide for the situation when another attorney is appointed to be the district attorney in the last sentence, which gives the authority to the Supreme Court to appoint an attorney pro tem if the district attorney fails or refuses to attend to and prosecute according to the law?
That's correct, Your Honor. If the district attorney fails to show up and either perform his constitutional duty to initiate and oversee criminal charges or attend according to the law, in terms of according to statutes that might give him otherwise a duty to appear, such as collateral review statutes, the court can remove him and provide a pro tem. But our point here is there is no duty to attend in collateral review cases, in capital collateral review cases, now that the statute has changed and given the DA that authority. The AG that authority. So that clause we submit also doesn't give the DA sort of any exclusive authority in trial courts or before judges having criminal jurisdiction.
But historically, since the enactment of the Constitution, the district attorney has fulfilled that role in collateral attacks, correct?
I guess my first answer to that question is at the time of the Constitution's adoption, there weren't the collateral review proceedings in dispute here, the specific ones, and in general, there were no forms of collateral attack generally, except for habeas corpus, which is provided by the Tennessee Constitution. And in terms of who represented the state in habeas matters that far back, I'll be quite candid with the court. I was not able to find anything in the case law that said who represented the state in those cases. All I know is the case law that we do have in more recent times says that the AG represents the state in habeas corpus matters. So that's what we've got for that. Your Honors, there is no serious doubt here that this act is constitutional. The constitutional text does not make any court the exclusive domain of DAs, and it says nothing about DAs defending final judgments from collateral attack. And there is no hint in the Tennessee precedent that Article 6, Section 5 constitutionalizes DA's statutory authority to defend final judgments from collateral attack. Your Honors, accepting McKay's position here would be a major, major shift in the understanding of the AG's significant historic role in Tennessee's trial courts, not just trial courts having civil jurisdiction, but also in trial courts having criminal jurisdiction. There's simply nothing McKay has pointed to here to overcome, again, the strong and mandatory presumption that this act is constitutional, and for that reason, we respectfully ask you to reverse the decision below. Thank you.
I wanted to hear a little bit about the standing issue.
Sure, and I'm glad you asked, Your Honor. I think we're here prepared today to abandon that issue, and the reason for that is I think one thing that myself and Mr. McKay and DA Mulroy can agree on is that we all want and need a merits ruling on this constitutional question because it's so significant and because it stands to impact so many cases statewide. And the reason that I'd give you for that is I think the standing issue is a little bit snake bit, probably part and parcel because the trial court refused to certify that issue. So I do think there is a legitimate argument that this court simply lacks jurisdiction to consider that issue given the trial court's failure, or not failure, but refusal to certify that issue and are not putting it in the appeal application. And I will point out in supplement of that argument, standing as we have raised it in this case and as it has always been raised is not a jurisdictional bar to considering the merits of a claim. Standing is jurisdictional in other contexts that don't apply here, but standing is not a jurisdictional bar to considering the merits in this case.
That's kind of what my question was.
Sure.
Okay.
Thank you, Your Honors.
Can I ask one other question, historical question?
Sure, yes.
I have no idea, and I have not looked it up. So when the 1870 Constitution was adopted, were all counties in Tennessee placed in a judicial district by legislation?
I will admit I have not, I assume that they were, but I don't know that for sure. I did not necessarily research that issue.
Just looking at the language that talked about for any circuit or district, and I was just,
What's the difference?
well, and I wondered, and/or did every county fit into a district at that point in time initially?
Yeah.
Obviously, they all do now. The question was, did they then?
And I'm just not sure. I didn't necessarily study that issue, Your Honor. I don't think it's dispositive in any way to this case, but yeah.
The other question I was going to ask
Sure.
with regard to standing, since it's dealing straight with the constitutionality, is there a reason that it's in this court versus, say, the Court of Appeals?
I think because it arose in a criminal case and because it's a criminal defendant who's raising the challenge primarily. No, I don't. Just because it's a
standing, or he's not. His question, he doesn't have any standing, right?
McKay, you're talking? Yes, and to be clear, we are not conceding that McKay has standing. That is not the basis of our abandonment of that argument. The basis of our abandonment of that argument is that we feel there's a good faith argument that the court lacks jurisdiction to reach that issue given that it was not certified by the trial court below. So if the court has any other questions, I'm happy to answer. Otherwise, we respectfully ask you to reverse. Thank you.
Thank you, Michael.
May it please the court. The parties in this case agree
Wait,
to... oh, yes, Your Honor?
you are, sorry.
I'm sorry, I apologize. Robert Hutton from Memphis, Tennessee, representing Larry McKay, the defendant in this case.
Thank you.
Thank you. May it please the court, Your Honors, the parties in this case in their briefing agree with the central tenet of the holding of the Supreme Court in the Superior Oil case, which said that the legislature cannot enact laws, quote, that impede the inherent discretion or responsibilities of the district attorney, the office of the district attorney general, without violating Article 6, Section 5 of the Tennessee Constitution. The disagreement that me and my friend have that's before the court is how far does that constitutional protection in Article 6 extend? Does it only extend to the entry of a verdict in a criminal case? Or does it extend to all proceedings before the trial courts having criminal jurisdiction, as it's been consistently understood until the passage of the act last year? Now, I'd like to highlight the three reasons why the position of the trial court below and Mr. McKay's position and the district attorney's position is correct, and that constitutional protection of Article 6, Section 5 extends to all proceedings before the trial courts with criminal jurisdiction. And that is based upon the plain text and plain meaning of Article 6, Section 5. Number two, the status of the law in 1870 when the Constitution was enacted. And number three is the purpose for the change in the law that occurred in 1853 when the people took from the legislature by constitutional amendment the power to appoint district attorneys and judges and vested it locally and the local people accountable locally. Now, Your Honor, let's start with the plain text of Article 6, Section 5. I would start off by noting there's no language in Article 6, Section 5 talking about collateral. There's not the word directed verdict, or through verdict or through judgment. Rather, what it does is it ties a district attorney to a court. If you look at the language, it says the first sentence creates the office of the Attorney General appointed by the Supreme Court. The second creates an attorney for the state for each circuit or district with a judge having criminal jurisdiction as provided by law that shall be elected for a period of 8 years, every 8 years, shall have been a resident of the state of Tennessee for 5 years, and shall have been a local resident for 1 year. The language itself doesn't create a what of substantive provisions, it creates a where. And the where is, and as has been understood from 1870 until last year, that if you're before a trial court exercising its criminal jurisdiction, that the representative of the state was the elected, locally accountable Attorney General. We also see a broad language of the powers in the last text, which says if the district attorney fails or refuses to attend or prosecute.
Actually, it says attend and prosecute.
Yes, Your Honor. I would cite it, I'm sorry, but there are two different duties, and if Your Honor looks at the trial court's opinion talking about it, it cites some older Tennessee Supreme Court cases that talk about those are two different functions. To attend and to prosecute are two separate functions. But Your Honor, you're correct. My point was that that's broad language talking about what the Attorney General does, the district attorney does.
That's the only place in the constitutional provision that gives any kind of description about what the district attorney's powers are.
Your Honor, it does, but there are a couple of things we know, and I'd like to clear up a couple of misconceptions, because the logic of my friend's argument was, well, this doesn't create any duties, it just kind of creates the office. But we know from Supreme Court cases that there are substantive protections there. Superior Oil held that the legislature cannot enact laws which impede the inherent discretion and authority of a district attorney general.
But that case was about specifically prosecutorial authority, was it not?
Well, Your Honor, and that, yes, it was, Your Honor. That Superior Oil had to do with the legislature passed a law requiring the district attorney to get permission from the water board. But we also see later in 1999 in the Ramsey case where the legislature, by private act, allowed the chief of police in Oliver Springs to have prosecutorial authority. That was also declared to be unconstitutional because, in other words, it wasn't taking away. The district attorney in Anderson County was still there, but they were trying to create those prosecutorial authorities in another particular office. That was also struck down as being
not related to the prosecution of crimes.
It does, Your Honor, and I'd like to, that's a good point getting into what does the prosecution of crimes mean. I would point out the case law is sparse, but precisely the case law is sparse is because this is the first time since 1870 that the legislature's ever tried to strip away from the district attorney their authority in these cases.
Well, how did the habeas proceedings get transferred to the Attorney General's office?
Well, Your Honor, and habeas is unique because the law under habeas, under Rebuttal, is that habeas is a civil proceeding. In fact, the very reason that this court held in the Rebuttal case that AGs could actually act in habeas cases is because the court held that they were civil proceedings and not criminal. Now, that makes sense for a lot of reasons because habeas is unique. All judges in Tennessee, all chancellors, all judges, all appellate judges have habeas jurisdiction. Habeas is found in Title 29, not in Title 39 or 40 dealing with criminal procedure. And I think what's most important about habeas is under Tennessee law, under Hickman, habeas cannot be used to challenge the underlying merit of a criminal judgment. In other words, all you can do in habeas in a case where there's a criminal judgment, is it void on its face like a probate court sentence somebody to death, or is this person in jail in excess of the judgment? You can't look beyond the judgment. That's the holding in Hickman. It's not a means in Tennessee to challenge an underlying judgment. Now, Judge Ayers, you're at the very good question, though, about, well, what does it mean to prosecute? And that's why I think it's very important, my second point, to look at what the law was in 1870. And why is that? Your Honor, the reason, there's a very important Attorney General opinion that was cited by my friend in his reply brief, and that's Attorney General Opinion 06097. And it's interesting because it's when the shoe was on the other foot. Back in 2006, the legislature was proposing to create an elected Solicitor General and take power away from the Attorney General. And there was a question about whether that was unconstitutional. General Summers, in Opinion 06097, opined that for the legislature to do that would be unconstitutional and violating Article 6, Section 5. And the rationale was that Article 6, Section 5 provides substantive protections, but they're not listed out. And what General Summers said is, no, what happened is that the constitutionalized the duties of the office of the Attorney General as they existed in 1870 when the Constitution was basically written. Well, that applies also with equal force, that rationale, to the District Attorney General. And he cites case law, old case law, talking about where the Supreme Court had interpreted it that way. Well, when we look at what were the duties of the District Attorney in 1870, we know that the District Attorneys prosecuted writs of error coram nobis. How do we know that? I've cited, to Your Honor, 3 published opinions from the Tennessee Supreme Court which used writs of error coram nobis in criminal cases prior to 1870. That was the Andrews case, the Fleming case, and State versus Disney. We also know from the historical information that we provided to Your Honors that district attorneys back then prosecuted lots of writs that were ancillary to just the regular prosecution. Writs of sine facie, which were ways of continuing judgments for some purpose. Peace warrants, which is an archaic proceeding, almost like a criminal injunction. But there were other kinds of ancillary proceedings that district attorneys utilized in 1870 other than simply representing somebody through verdict. And finally, we know that from the status of the law itself at the time, because we see in the statutes at the time that the Constitution was enacted that the district attorney had the jurisdiction to prosecute on behalf of the state in any case where the state was a party or was in any wise interested. Well, since the state is always a party to a criminal case, the language of those broad statutes must have a meaning of a much broader scope than just the district attorneys represented somebody through verdict in a criminal case. No, what the law was at the time is what the law was until last year, that before the trial courts exercising criminal jurisdiction, the district attorney was who represented the state, and then on appeal in front of the appellate courts and in front of the civil courts, it was the Attorney General that represented the state. Your Honor, my last point about what the court should look at is the purpose. We know in the first 2 constitutions of Tennessee, the 1796 and the 1838 Constitution, the legislature appointed all judges and all prosecutors. That was the law. But it was changed with an amendment by the people in 1853. There's a lot of historical evidence of the rise of Jacksonian democracy, the concerns with political craft, and the concerns with having Nashville basically appoint the judges and prosecutors in Far East Tennessee and Memphis. So what happened was the people took that power away from the legislature and required that from those two offices, judges and trial court judges and prosecutors would have to be locally elected and locally resided. So what that safeguard that gave to a defendant is, if I'm going to be deprived of my life or my liberty, I have a right in Tennessee under the Constitution to be tried by a local prosecutor that lives locally, knows the local people, and is elected and accountable to the local people, and tried by a local judge that's locally elected and accountable to the local people. What the legislature is trying to do with this act is claw back that power that was taken from them with the Act of 1853, the Amendment of 1853 that was then incorporated in the 1870 Constitution. And Judge Montgomery, I'd kind of like to go to one of the questions you asked was about constitutional and how this arose in a criminal case. There's a very analogous case that I think I'd like to call to Your Honor's attention, and that's State ex rel Carruthers versus Barrett. And that is a case where a DUI defendant challenged a law at the time that allowed judges, trial judges, not to be elected but to be appointed in some of these municipalities that had criminal jurisdiction. It arose in a criminal case because he said, I have a right under Article 6, Section 4 to be tried by a judge that is elected and accountable to people. The Supreme Court agreed, struck down the law in that case. That's interesting because it's a criminal case where a criminal defendant is challenging on constitutional grounds. We honor both the right to elected judges and the right to elected prosecutors came at the same time with the same amendment. Those are safeguards in our Constitution. And the frightening thought is, under my friend's rationale, the Attorney General's rationale, the state could pass a law tomorrow saying all capital defendants in the future are going to be prosecuted by a prosecutor that's appointed by the legislature and by a judge that's specially appointed by the legislature. And under that rationale, there's nothing that the defendant could do because, before they were taking the position there was no standing. And they say, well, you have suffered no harm. Your Honor, we've suffered harms because these are structural protections in our Constitution. In the same way that the right to a jury trial is a structural protection, the right to a court, the right to have a lawyer, all these kind of rights, we can't say, well, if you had a lawyer, it wouldn't have made a difference, or a judge or a jury wouldn't make a difference, or whether the judge is elected or appointed, that would make a difference. No, this is part of the structure of our Constitution to safeguard our liberty. And what part of it is in Tennessee is that if I'm going to be deprived of my life, like Mr. McKay is, I have a right to have an elected, accountable local prosecutor and be tried before an elected and locally accountable judge. That is the core meaning of that. Now, Your Honor, there are other points that are raised in the Attorney General's brief. I do think it is important to show why it makes a difference, why trial courts are different than like Your Honors, like appellate courts. Trial courts are different because there's a witness stand. Trial courts are where evidence is taken in criminal cases or any kind of case where new claims are evaluated. And the district attorney's job is not to defend a judgment at all costs. It's to exercise justice. And what my point is here, Your Honor, if, say, we had a criminal trial where somebody's sentenced to death or sentenced to 20 years, and after the trial, all of a sudden it's discovered that the three key witnesses were all bribed by a policeman and lied. If that evidence was legitimate evidence presented in a post-conviction petition, then the district attorney's duty is not to defend the judgment in all case, but to look at the evidence, decide what position on the behalf of the state to take in front of the court with respect to that evidence, decide whether or not to marshal evidence against that. We have several procedures in our law where evidence can be developed, and anytime there is an evidence to be developed, there's going to be a discretion by the person on behalf of the state about whether to agree with that evidence, whether to contest that evidence, what kind of evidence to develop that is in response to that evidence.
Are you saying the Attorney General's office wouldn't have that same duty, obligation?
Your Honor, what I'm saying is that by Constitution, since 1853 in our state, one of the safeguards is the person deciding those cases should be somebody that lives locally and is accountable to the local voters.
But the person deciding those cases is the judge who's hearing all of that proof proof in making a decision on the collateral attack against the judgment.
Well, Your Honor, it's sort of a dual day. Obviously, courts, even in trials, judges obviously have very critical roles about whether evidence is relevant, whether it's admissible, whether it's unduly prejudicial, ruling on the law. But there's also the role of the state, the system before a court, taking a position as to whether this evidence merits relief, whether or not what evidence to muster to present to judges and to those courts with respect to those claims. So,
Collateral attack, like an error quorum nobis that we're discussing here, it's the petitioner's burden to bring forward what they think, is new evidence, and it's technically being defended by the state at that point.
yes, Your Honor, or it's being prosecuted in the same way we talk about the state prosecutes on appeal, though technically the defendant files a notice of appeal.
It's not like the state's trying to gather evidence and decide, how to charge, what evidence you have, whether to pursue the death penalty. I mean, those kinds of issues don't seem to me to be the same on a collateral attack.
Well, Your Honor, there are a couple of things. First of all, I would say that the discretion, the cases talking about the discretion of the district attorney are more than just charging decisions. We see in State versus Welsh, for example, it's what evidence to present. We see in State versus Lehman at any point in the trial that the right to null pros that only can be disturbed by a court by manifest injustice. And I think, Your Honor, one of the ways to that the role of the district attorney is to make sure that justice is done. He's a local official. We've called it, our Supreme Court called it the most powerful office in the state. And Your Honor, I would point out this, that the way that it's our Constitution is structured, if we think about this, the language talks about the legislature is perfectly free to change the jurisdiction of a court. It can create new criminal offenses, as it's done. Felon in possession of firearms laws and drug crimes, DUI didn't exist back in 1870. And it can abolish those crimes. Likewise, it can create new defenses like post-conviction, or it can abolish them. But if it creates an offense that's a part of the court's criminal jurisdiction, the plain meaning of the Constitution and the understanding for the last 150 years is that it's the elected district attorney that represents the state in those particular cases. The two, when one looks at the language, are tethered together. That's how it's been consistently understood until April of 2023, when the legislature tried to claw back that which was removed from them by the people in 1853 and 1870 in our Constitution. And unless there are other further questions, Your Honor, we would ask to affirm the well-reasoned opinion of the trial court in this case.
Thank you, Mr. Tucker.
Thank you.
Good afternoon, Your Honors. Stephen Mulroy, the District Attorney for the 30th Judicial District. Before I begin, I'd like to introduce two elected district attorneys who are with us today, Craig Northcutt and Fred Agee in the back. Oh, and I'm sorry, and Colin Johnson as well. My apologies. May it please the court. There is no dispute in this case from any party that there is a zone of constitutionally protected DA discretion. The only question is whether that zone of constitutionally protected DA discretion suddenly stops at the point of conviction or sentence. I believe not only does the plain language of Article 6, Section 5 say that there is no such bifurcation, but the history behind its adoption, the contemporaneous understanding of what the duties of the DEA were at the time of its adoption in 1870, and the opinions of both this court and the state Supreme Court all militate against any such artificial distinction, particularly when you consider the reasons why the state Supreme Court believed that it was necessary to recognize constitutionally protected DA discretion, i.e., DAs have extremely broad discretion, virtually unbridled discretion, in the words of the Tennessee Supreme Court, a heightened ethical responsibility to not just go for victory, but to be a minister of justice, and therefore there is a need for the check on that power of the person being a local resident and local elections. Those rationales apply regardless of whether we're talking about a pre-conviction or a post-conviction statement. The second sentence of Article 6, Section 5 has been discussed a little bit. I won't belabor it. It seems that a proper reading of it is that where there is a court with criminal jurisdiction in a circuit or a district, then the attorney for the state, quote unquote, is the local resident locally elected. Now, I know that the Attorney General has argued that that clause may have a different understanding, but I would cite to the court the Tennessee Supreme Court's decision in Effler v. Purdue Pharmacy, where the court said that following this provision, that DEAs have the duty to prosecute, quote, those cases falling within a judicial district's criminal jurisdiction. And contrary to the argument that was made earlier, it is an exclusive power as has been recognized by the Tennessee Supreme Court. In the Ramsey case that was mentioned before, the court said that the DA and only the DA has the power, pardon me, the DA and only the DA can make the decision whether to proceed with a prosecution for an offense committed within the district. And in a case called Spradlin, having to do with grants of immunity, the Tennessee Supreme Court said that the DA has the sole duty, authority, and discretion to prosecute criminal matters.
And again, all those cases talk about prosecution. So is it your argument that doesn't matter, that doesn't stop, prosecution doesn't stop at conviction?
No, it doesn't, for a number of reasons, Your Honor. First, again, the plain language of Article 6, Section 5 doesn't talk about pre-conviction, post-conviction. It says that if it's a case of criminal jurisdiction before the circuit or district court, the quote-unquote attorney for the state is the local resident, locally elected. And the contemporaneous understanding of the duties of the district attorney as set out by the statute defining the duties at the time of the adoption of Article 6, Section 5, which was cited by the Attorney General, is quite broad. That language that you heard earlier about where the state is a party or is in any wise interested, those last 6 words would not have been necessary if the conception of the DA's authority was as constricted as was mentioned by the Attorney General. I know that there was a question about how the text of it doesn't list the duties. Again, there is no need to list the duties because it simply says it's the DA who is the attorney for the state in such a case. And that 2006 Attorney General opinion that was mentioned by Mr. Hutton, the Attorney General specifically said it doesn't matter that there's no explicit list of duties for the Attorney General. Article 6, Section 5 constitutionalizes those duties that were understood at the time of the adoption. Well, that applies also with respect to DAs. If it applies to the first sentence of Article 6, Section 5, it must apply to the second sentence of Article 6, Section 5 as well. I know that one thing I wanted to emphasize is the Attorney General has conceded in this case, Your Honors, and the Tennessee Supreme Court has made clear in State v. Culbreath and a series of other Tennessee Supreme Court cases that the constitutionally protected discretion of DAs goes beyond initial charging decisions to a whole range of discretionary decisions that apply throughout the entire criminal justice process. What evidence to submit, what witnesses to call, what agreements to make, what grants of immunity to agree to, whether to seek the death penalty, whether to withdraw notice of the death penalty. All of those have been recognized as constitutionally protected acts of discretion. And Your Honors, I would say that those decisions are just as salient and just as important in a post-conviction proceeding like we have before us as they would be in a pre-conviction proceeding. You still have to, even in a post-conviction proceeding like this one, in the quorum nobis, you have to make a decision about what evidence to put on, what witnesses to bring, what agreements or stipulations to make, whether to withdraw notice of the death penalty, whether to grant immunity. All those decisions have to be made. There's discretion, broad discretion, a heightened ethical duty, and therefore there is just as much of a need for the check on that power of local residents and local elections. There are a few minor matters. The Attorney General mentioned the Spurgeon case. The Spurgeon case, which is an old case, explicitly decided not to decide any constitutional question before it. It has language suggesting that there might be constitutional problems with the legislature trying to strip duties away from the DA or the AG, but the more recent cases in Ramsey and Superior Oil clearly say the DA has exclusive authority and that the legislature cannot impede the inherent responsibilities and discretion of the locally elected district attorney. There was a point made about this is all a matter of statute and that these statutes were passed after 1870. I would just point out with respect to that, again, the plain language of Article 6, Section 5 just says whatever's going on, if it's a matter within the criminal jurisdiction of the district, then the attorney for the state, quote unquote, is that locally elected person. That's consistent with the broad understanding of the contemporaneous duties as set out by the statute, and also on a more fundamental level. Every time a prosecutor prosecutes, they are prosecuting pursuant to some statute. That was true in Ramsey and Superior Oil, even though the Supreme Court struck that down and said that was a violation of the DA's discretion. There are any number of statutes creating offenses today that were not in existence at 1870, and the legislature could repeal all of them tomorrow. But nonetheless, while those statutes are on the book, and there's a matter within the criminal jurisdiction of a particular district, then under a plain reading of the language of Article 6, Section 5, we have to decide who the attorney for the state is in that case. And that must be someone who is locally elected and a local resident. There's a question about whether, the fact that there are some courts where have both civil and criminal jurisdiction. Again, that is not problematic, because I think the plain language indicates that where there is criminal jurisdiction, that's where it's the DA's domain, and that's where the protection discussed in Superior Oil and Ramsey apply. I think that there's also a point here about the scope of this case and what's at stake in this case. There is a DA, Ray Crouch, who recently, a couple of years ago, successfully got a death penalty sentence. The question here is, when that comes up on post-conviction, will he be the one that is able to litigate that? Because he was the one that was there at trial, and he was the one that is going to be responsible to the local voters. Under the DA's theory, the legislature could take away from the locally elected DAs authority over motions for new trial, motions to modify a sentence, revocation of probation, any number of things. And the legislature won't stop there. The camel's nose is in the tent. There is already a pending bill, cited in my brief, in which the legislature would purport to take away from locally elected district attorneys and give to the Attorney General pre-conviction prosecution authority over anything involving organized crime or human trafficking. There must be a line to be drawn somewhere, and there is no reason to say that that line has to stop at conviction or sentence, given the broad language of Article 6, Section 5, the broad language of the statute defining the duties. There's nothing in the case law that would suggest there needs to be this distinction. And so for those reasons, I think it needs to be recognized. I'm running out of time, so I don't want to move on to too many other things. I would just say, Your Honors, that for all the reasons mentioned, this court respectfully should affirm the lower court and hold that the act is unconstitutional. Thank you.
All right, thank you, General Mulroy. General Spangler, rebuttal.
I'll be brief. I don't know that we've gotten into too much here that's beyond what's in the briefs already, but I would just encourage the court to focus on the text of Article 6, Section 5. That's where any analysis, whether it's statutory or constitutional, that's where the court's analysis should start, is with the text of the Tennessee Constitution. And again, we submit that there is nothing in that text that exclusively ties DAs to the trial courts of a given jurisdiction or the judges having criminal jurisdiction in a given district. There's some suggestion here that this case is new from the standpoint that it's the first time that the AG has ever been given collateral defense authority, but that's just not true. And again, we point to habeas corpus. It is a means of collaterally attacking a final judgment. It's one of the most fundamental means. The effect of habeas relief is to declare the judgment void, so it is a means of collateral attack. There is a little nuance that I will acknowledge. The reason the AG, at least the case law says, the reason that the AG gets to represent the state in habeas is because it is a civil proceeding, and then there's the statute that gives the AG authority to represent the state in civil proceedings. The difficulty that I think the other side has here is habeas matters can only be filed in courts exercising criminal jurisdiction. So I acknowledge there's an anomaly there. It's strange to say that it's a civil case, but it's filed in a criminal court. But only courts exercising criminal jurisdiction can actually grant habeas relief for criminal restraints. So the AG has had collateral defense authority in collateral review proceedings in habeas. There's never been a challenge to that in terms of that violating Article Article 6, Section 5, and so we submit that as an example of a longstanding situation where the AG has had collateral defense authority. I do want to talk briefly about this 2006 AG opinion, which is not binding, and I don't say that because I want to walk away from the opinion, but Attorney General opinions are not binding. But what that decision basically, or not the decision, the opinion basically said is a law stripping the AG of basically all of their powers and giving it to an elected Solicitor General would violate Article 6, Section 5. So the first response I have to that is this situation is just not comparable. We are not stripping the AG, the DA of all of his or her powers and giving it to the AG. We're talking about a very narrow category of collateral review cases, and we're talking about a subset of cases that don't infringe on the DA's constitutionally protected discretion under the common law to initiate or oversee pending criminal charges. And then the second point I'd have about that, and it's support of this first point, is it's interesting because that 2006 opinion talks about this Prescott decision, which is an early 1800s Supreme Court decision, and it talks about the powers and duties of the sheriff. And that's another similar constitutionally created position that does not in the Constitution list all the details of that officer's duties, but nonetheless what Prescott suggests is that in terms of a constitutional sense, the duties of that office should be understood as what the powers of that office were at common law. And I think the analogous situation here is the DA's powers at common law was the discretion to decide who to prosecute and for what offense. And that is the only duty that Article 6, Section 5 protects. It does not protect collateral defense authority. I'm happy to answer any questions the court may have. Otherwise, we respectfully ask you to reverse.
If under Article 6, Section 5, the legislature has the authority to strip some of the powers from the district attorney, what stops them from stripping all the powers under this Attorney General opinion you mentioned?
Sure. I think we get into dangerous territory when we start talking about laws that give anyone else the authority to initiate a criminal charge, file an indictment, file a warrant. And I would even go so far as to say I think we get into trouble when we have a pending criminal charge. The oversight over the disposition of that charge, I think that's also dangerous territory constitutionally in terms of the Superior Oil and Ramsey cases. But the DA's authority to initiate or oversee pending criminal charges just has absolutely nothing to do with the defense of collateral attacks.
So what are some of the powers you think the legislature can strip the District Attorney General's office of?
The power to defend final judgments from collateral attack. In this case, for one, it's hard for me to speculate beyond that. I mean, there have been discussions of things, I think probation revocations were mentioned. I think probation revocations may be different because that's another instance where to initiate a probation revocation, you have to have a charging document. You usually have a warrant alleging the violation of probation. So I think that would be dangerous territory. I think other things like post-verdict, post-judgment proceedings, like motions for new trial and things like that, those might be on the table to take away. I mean, this is all speculation. I'm not suggesting the legislature can or should do this. I'm just saying that's the line we've drawn. We don't come today to try to say what could be taken away. Our main point is to say, or I guess we do come to say it could be taken away in terms of collateral review, but not beyond what initial charging decisions and oversight over pending criminal charges. That's the line. That's the line that we draw on this.
At the power they've already attempted to take away.
Not just there, Your Honor. I think, again, the Prescott decision talks about what's constitutionally protected is what was protected at common law. And again, that's the initiation of criminal charges and the oversight of those charges. Really just the initiation of criminal charges is what the common law talks about. It's not until you get into the decisions like Ramsey and Superior Oil and even the Culbreth decision that start talking about these things like the investigation, the putting on of proof, kind of the meat of what it means to prosecute a pending criminal case. I think under those decisions, that's also dangerous territory constitutionally. But I think there is a nice clear line in the sand here with a final judgment, and that's our position in that case, in this case. Thank you, Your Honors.
Let me ask you something. I don't typically look at this section of the Constitution because this court doesn't deal with constitutional issues that I've ever, in the 8 years I've been on the court, we have not dealt with a constitutional issue, and as a trial judge either. But I was reading one of the sections that talks about jurisdiction of the courts, the circuit, chancery, and other inferior courts. That's in section 8 of this article. And it says that the legislature can change it.
Sure.
Jurisdiction.
Sure.
Now, of course, the definition of jurisdiction, what does that mean? I know a few years ago, this court had the responsibility for when there was a capital case and the first appeal was heard in this court. And a few years ago, the legislature took out this court being involved, and it goes now straight to the
Sure.
They changed our jurisdiction.
Sure.
So would jurisdiction also include things like a collateral attack of a final conviction?
I think so. I mean, I think,
In other words, could the legislature, under Section A, changing the jurisdiction, say that the circuit court can no longer hear a writ of error coram nobis in a capital case?
I think that's probably true, Your Honor, and I
I
think,
don't know what they would do, where it would go,
yeah.
but could they do that?
I think they could. I think they could maybe say these are now civil in nature and they go to circuit courts or other courts. And I think they could say collateral appeals go to the Court of Appeals rather than the Court of Criminal. I mean, there's practical reasons for not doing that, right? Because it's the continuation of a criminal case and it makes sense to have people that are familiar with criminal prosecutions. But I think they could do that. But
So if they take the jurisdiction away from a criminal court, how does that, would that impact at all what we're talking about here?
right, I think under
DA?
yeah, I think under our position it would not. And again, because our argument is that the DA is not somehow tethered to the judges having criminal jurisdiction.
Suppose they transfer it to a civil court.
Sure.
Well, clearly, in civil court, the state is represented by the Attorney General by
Sure.
by law, right?
Sure.
Okay. So if the legislature should change those collateral attacks and move it into civil court, automatically would
Sure.
that become the state AG?
I think so under the
I know you're,
sure.
It's not what we're dealing with.
Sure.
I'm just talking about conceptually.
Yeah, I think if they declared that certain actions go to a particular court, including civil courts, and they deem those actions civil, then the statute kicking in that gives the AG authority to represent the state in civil cases would kick in, and we would represent the state in those cases. I mean, that's not at all what we have here. I want to be clear, but
We do.
yeah. So, unless the court has further questions, again, we'd respectfully ask you to reverse. Thank you.
Thank you, counsel. That concludes our afternoon docket. Appreciate you being here.
All rise.